What is insurance bad faith? My name is David R. Price Jr. and I'm a personal injury trial attorney in Greenville, South Carolina. I dedicate my practice to helping injured people, and I want to share some valuable information with you. Insurance bad faith is a term lawyers use to refer to an insurance company's breach of its duty of good faith to its insured. Insurance bad faith can arise in one of two contexts: first-party bad faith or third-party bad faith. To understand the differences between the two contexts, it's important to understand that an insurance company's duty of good faith is to the person that purchased the insurance policy, not to the person who was injured by the insured. In that context, when we talk about third-party bad faith, what we're referring to is an insurance company's duty to make a good faith attempt to settle an insured's liability to an injured person within the policy limits. In that context, an insurance company does not owe the duty to pay an injured person's bills. It owes a duty to the at-fault driver who has the insurance to resolve the at-fault driver's liability to the injured person within the policy limits if the injured person offers to settle the case within the policy limits. Put another way, an insurance company for an at-fault driver is not entitled to unreasonably refuse to tender its policy limits when demanded by the injured person if the refusal to pay the policy limits is likely to result in a verdict in excess of the policy, which would result in personal liability by the at-fault driver to the injured person. In such an instance, the at-fault driver may have a claim for breach of the duty of good faith to settle within the policy limits. When set up properly by the injured party through a type of settlement demand known as a Tiger River letter, an insured party may have a claim directly against its insurance company for any portion of the verdict over and above its policy limit. That claim can then be assigned by the insured to the injured party, and the injured party can then pursue payment of that claim directly from the insurance company. The other type of the breach of duty of good faith that we discuss is called first-party bad faith. First-party bad faith is another type of bad faith. In that context, what we're referencing is an insurance company's duty of good faith and fair dealing to the person that actually bought the insurance policy. This type of bad faith does not result from a third party's claim against the liability policy of an insured. It results from an insured's claim against his own insurance company. This normally occurs under types of policies such as a homeowner's hazard insurance policy or an underinsurance policy, where the insurance company owes payment directly to its insured. In this type of case, an insurance company owes a duty of good faith and fair dealing to properly investigate the claim and to pay to its insured any amounts that the insurance company recognizes is fairly owed. This means an insurance company cannot unfairly deny a claim and require its insured to file a lawsuit to determine the amount that it is entitled to under its own insurance policy. When an insurance company breaches its first-party duty of good faith and fair dealing, it may be liable to its insured for attorney fees and for other damages incurred by the insured in being forced to pursue the unnecessary litigation. My name is David R. Price Jr., and I handle cases against insurance companies every day. If you've been injured and are getting the runaround from an insurance company, then I want to help you. Please call me at 864-271-2636 or visit my website at greenvillelegal.com. I'll give you the dedicated personal representation that you deserve.